It's 2 p.m., so it's time to start. We would like to welcome you to our webinar regarding out-of-court and court restructuring. My name is Cezary Zawiślak. I'm an advocate and licensed restructuring advisor. And next to me is my colleague Łukasz Czelepak. He's an advocate trainee. And we divided our presentation into two parts. The first one relates to the out-of-court restructuring, and the second one is the court restructuring. We think that if you will have any questions, please let us know on the chat, or you may ask us once we finish our presentation. As I said, the first part relates to the out-of-court presentation, and my colleague Łukasz, he will start with his presentation. So please, let's go on.
Okay, so first of all, let's focus on what is the out-of-court restructuring. Out-of-court restructuring, also referred to as consensual restructuring, does not involve any public authorities and is almost strictly private in nature. If we don't count the restructuring of debts towards the public creditors. It has a contractual nature, that is, it is conducted through a civil law instruments, which I will present in a second. The main advantage of out-of-court restructuring is that it is less formal and therefore presumably easier, more flexible and faster for the parties involved. The biggest disadvantage of out-of-court restructuring is that it is fully voluntary. This means that all creditors whose debts that we want to restructure must agree separately on a given measure. It is not possible to force someone to out-of-court restructuring, like will be the case with the in-court restructuring that Czarek will present. Okay, so I wanted to first say a few things about the factors that the debtor has to consider when he wants to choose the out-of-court restructuring. First of all, it is important to focus on the type of creditors that we are dealing with, because public creditors like tax authorities and social insurance institutions are different than private ones, in that when they are involved, the debt restructuring process is regulated in the statute and is a little more formal. The procedures for those kinds of creditors are quite similar for all of them. The debtor must file appropriate application where it must prove that his situation is distressed, that he has problems with the liquidity, and present some kind of restructuring plan. The debtor may apply, first of all, for the deferral of payments or dividing the payment into installments. Those are the two main options for the debtor, but there is also an option for the redemption of claims, but it is very exceptional and is not very likely to happen in most scenarios. When it comes to the acceptance rate, so to speak, of those applications, it's quite high when the application is lodged for the first time by the debtor. If he has continuing problems with liquidity, then the authorities will not be likely to accept such applications. The other thing to consider is that the process will be much easier when the assistance is less than 200,000 euros, because this is the threshold of the de minimis public aid, which makes the process much faster and easier. For the time of the pandemic, the restructuring of tax debts is free of charge. In normal circumstances and with regards to all other public creditors, the debtor must pay a special extension fee. So this is something that may be beneficial for the time being. When it comes to private creditors, the parties are entirely free to choose the restructuring tools, and I will present those in a second. But from the private investors, I would like to focus a little bit on the banks, because banks have the special rules that were introduced with the anti-crisis shields, which basically compels them to participate with the negotiations with debtors and restructure the credit facilities like the COVID, let's say, never happened. The situation of the credit of the debtor is assessed as of 30th of September 2019. So this might be quite also quite beneficial from the debtor perspective, but it must be pointed out that the bank is not obliged to do anything other than participate in the negotiations. So always there will have to be an agreement in place after all. So okay, after the type of creditor, the important thing is also the number of creditors, because the out-of-court restructuring is best suited for a small number of creditors. Especially, it's in most cases it's used when there are like a few big creditors, like banking institutions or maybe some key counterparties that have big receivables toward the debtor. So that's probably something that the debtor will use when the debtor can use the out-of-court restructuring. If there are more creditors, especially smaller creditors who are not really willing to participate in those kind of negotiations, then probably in-court restructuring will be more appropriate, because their consent not always will be required. When it comes to the next factor, the debtor has to also think about value of debts that he has and the situation of the company. Because basically restructuring process must be preceded by the analysis of the situation of the company. If the indebtedness is significant and there is no plan for improving, or no prospect for improving the situation of the debtor, sometimes the out-of-court restructuring may not be the best option. The managers have to remember that there are certain risks involved with, let's say, playing with the indebtedness and trying to, let's say, cure the situation without the involvement of court. Because most importantly, the management board members of the companies may be personally liable for the debts of the insolvent company. The most important thing here is that such liability may be avoided if the manager files for bankruptcy or manages to procure that the restructuring proceedings are initiated within 30 days from the moment that the company became insolvent. Out-of-court restructuring may therefore be the most optimal solution, but this is the most important risk, so it must be borne in mind when deciding upon which option of restructuring to choose. The good news about the 30-day period for the managers is that it does not run during the COVID epidemic. So management board members are in this way a little better protected, although it must be remembered that the creditors also can file for for bankruptcy, for example. So if the restructuring process is not going as planned, then they may go to the court and initiate the whole process. So this is not a solution for everything, for sure. There are also more dire consequences of inability to pay off the creditors, such as even criminal liability or prohibition to conduct the business activity. However, those sanctions are limited to the rather exceptional cases of intentional misconduct or gross negligence. So we won't focus really on that here. Okay. There are also a few more factors that have to be considering when assessing the possibility to successfully restructure the debt without the court intervention. For example, we can point out to the relationship with investors, because sometimes investors are less likely to opt for losing a counterparty than even forgiving his debt. So when the relationship is well established, it is more likely that the creditor will be willing to cooperate. Another very practical issue is the communication with the creditors, because sometimes it is very hard to communicate with some business partner or reach a decision-making person. So this is also something that may be a surprising obstacle. Also, there is an issue of the character of claims, because we can divide the claims into disputed and undisputed ones, and the disputed claims are much harder to restructure, because it's much harder to persuade someone not to enforce a claim if we are not acknowledging it. So this is also something that may be problematic for restructuring. And the last factor that we chose for restructuring perspectives is the access to public aid, other forms of anti-crisis assistance, and basically other forms of financing. Because if the debtor is able to show in any way that it will be able to acquire some financing, it makes it much easier for him to negotiate with the creditors. So that's always something, some leverage on his side. Okay, now let's quickly jump to the restructuring tools. As I have mentioned earlier, there is a number of civil law instruments that may be used in the restructuring process. I will now try to quickly present some of them, though this is not an exhaustive list. There are many, many more of them, but those are the ones that are most likely to be applied in the restructuring scenarios. Okay, so the first method that I chose is the standstill agreement. And this is the contract which regulates the temporary relationship between the creditors and the debtor, which constitutes the first step towards concluding final restructuring or refinancing agreement. It sets the stage and prepares the ground for further negotiations. It is important that it is important with the standstill agreement that all important and relevant creditors are involved with this arrangement, as many facility agreements or other forms of financing contain the clauses that stipulates that default in one of those financing arrangements might create the default in another. This may create the domino effect and therefore basically destroy the efforts of the debtor. therefore, such an agreement must cover all the important financing agreements to be basically successful. What is often regulated in such agreement are basically what creditors and debtor may and may not do during this negotiating period that leads to the final restructuring agreement. In most of the cases, there are prohibitions, for example, to creditors to change the financing agreement that will not be beneficial to the debtor. For example, interest rates or margin cannot be increased, the creditor cannot demand a new security, etc. Also, oftentimes there is also an obligation of the creditor that he won't limit to a certain point a renewable financing, so that the debtor, even though his situation is distressed, he may still operate quite, let's say, in the ordinary scope of business. Also, there are obligations that the creditors won't accept the payment of debt which is not due and payable, or that it won't start the enforcement proceedings, or commence other actions that may lead to the enforcement. For example, creditors are obliged in such contract that they will not terminate the contract. There are also other features of such contracts. For example, that the due and payable debts are deferred, so that the situation of the debtor is a little improved. But there are also obligations, of course, of the debtor, which are basically, we could summarize it to say that he's basically obliged to conduct the business in the ordinary scope and not do something exceptional. For example, with key assets, the debtor cannot also create new security interests. He has the obligations to give information about his enterprise to the creditors and or give them ability to inspect the business operations or the books of the company. So this is basically like the non-aggression agreement, allowing the debtor not to enter the insolvency state and basically regulate the relationship for a limited period of time. And this agreement, in most cases, if nothing extraordinary happens during this standstill period, the creditors and the debtor are entering into the final restructuring or refinancing agreement, where the debts are restructured, for example, through the deferral of payments or the division of payment into installments. But that's really case specific, so it's hard to talk about all the possible scenarios that may happen. I think that we can move on to the second instrument I wanted to discuss, which is datio insolutum. This is a situation where the debtor, with the consent of the creditors, does something different than previously agreed, and in this way releases himself from the obligation. It is most commonly used in order to extinguish pecuniary debt by making some kind of in-kind performance. For example, delivering some products that the debtor is able to manufacture himself, or assigning some of his rights that he enjoys, or providing some services that he may offer to the creditor. A good example of this tool is also an issuing of promissory note instead of paying, for example, of a loan. It's worth to mention that this method of restructuring is beneficial from a tax perspective, as there is no civil law transaction tax attached to it. Okay, the next thing we wanted to discuss is the novation, which is similar to datio insolutum, but gives the debtor a little more options. Novation creates a wholly new obligation, which may be distant in the future and have different legal bases. And the difference between the novation and datio insolutum is that after novation, the creditor is not satisfied yet, but has a new basis for his claim. A good example of novation is the conclusion of a loan agreement under which the debtor pays his former debt toward the creditor from the granted loan. In this way, the deadline for payment may be extended and creditor may claim additional interest, which will be beneficial for both parties. Both of the instruments that I mentioned, and even the first one, when it comes to the restructuring agreement, those instruments are often accompanied with some kind of security interest that debtor establishes in consideration for the new terms of the agreement. And here the options are almost unlimited. There are mortgages, pledges, etc. So there is plenty to choose from. Okay, the next instrument I wanted to discuss is the release from the debt, although I think I will not focus on this because this is very uncommon and happens only in well-established business relationships, where losing a counterparty is a worse scenario than forgiving some of his debts. In most cases, when the release from the debt happens, it is only partial. So the creditors only forgives, for example, the interest or some part of the principal amount that the debtor owes him. Okay. Another thing worth to talk about is the set of future receivables. This tool is possible if we know that in the future the creditor will owe us some amount of money, and now we owe him also some amount of money, but our debt is already present. In such scenario, we may conclude a contract by which we will make a set-off of future debt, and in this way release ourselves from the obligation. This allows us, for example, to not to pay any interest. So it may be beneficial from the debtor perspective. The last tool that we have on the presentation is the rebus sixtantibus clause. This is not really out of court restructuring option, because this is basically a cause of action, a lawsuit that may be filed in order to change the contractual terms or even terminate it by court if there is extraordinary change of circumstances. This method is not really popular because it must be applied separately to creditors. So there is not an option to for example, sue all of the creditors and try to basically use this cause of action against them in aggregate. And plus there is the problem with time, because it basically the litigation like that takes a lot of time. So it may not be the most popular of the options that the debtor may have. Okay, I also wanted to talk a little bit about the dangers of out-of-court restructuring, because even though this is the most flexible and fast way of restructuring the debts, there are some risks attached to it. Apart from the liability, possible liability of the managers with their own personal assets that I have mentioned earlier, there are also different risks. To mention the most important ones, badly conducted restructuring may lead to implied acknowledgement of disputed or even undisputed claims. Because in many cases, the creditors, when they are negotiating with the debtors, will require that the debtor acknowledges their debt in a formal agreement. And this is totally understandable. However, before that happens, it is important to have all options open and try not to at least worsen one's situations. Therefore, all communications with creditors might be well thought over and professional. If the disputed claim is acknowledged, then it is no longer disputed. Also, if undisputed claim is acknowledged, then the limitation of claims period is interrupted, which means that it starts from the beginning again. So, for example, if the limitations period was almost over and the creditor would have no chance to recover the claim, then acknowledging the claim basically renews the obligation. So that's something that the debtors must be aware of. Another problem is that sometimes one creditor may cause problems for the entire process of restructuring, because if he is unwilling to cooperate and undermines the endeavors, it may lead to the so-called domino effect that I have mentioned earlier. He may, for example, start the enforcement proceedings and in this way scare the other creditors that would be willing to cooperate. But only most creditors want to cooperate if the situation is stable and everyone has this, let's say, the level playing field. If someone is after the debtor's assets, then other creditors may panic and try to realize at least some of their debt as soon as possible as well. So this has to be taken into account. Okay, the last thing I wanted to mention are some golden rules of out-of-court restructuring. I think that I won't discuss them in detail, but I will only go through them and say a few words. First of all, when negotiating with the counterparties, the debtor must build the trust and not do anything that could undermine such trust. Basically, the creditor should not do anything that could, the debtor cannot do anything that could undermine him in the eyes of creditors. For example, treating other creditors better, or doing something with his business that may create risk of not fully satisfying other creditors. The out-of-court restructuring process must also be well coordinated, because all communications and actions must be conducted in a uniform way and most importantly in a professional way. And only by doing that, the restructuring will be successful, because, as I mentioned, not treating the counterparties the same, or basically neglecting some of the debts may lead to huge problems for the restructuring. Also, when it comes to starting the restructuring, the important feature is the stabilization, and it should be the first goal in the restructuring process, to achieve an early agreement, for example, in the form of standstill agreement that I was referring to earlier, that would set the rules of the game, so to speak, for the time being. The debtor should be realistic and truthful towards the creditors, but also create a narrative that the creditors will want to believe in. So, okay, and the last thing is the legal safety, because in the restructuring process, it's very fragile, and companies should continuously monitor its situation and take measures appropriate for the time. If the restructuring process, which is done out of court, is not headed in the right direction, then probably in-court restructuring must be considered, which is basically connected with the things that I mentioned earlier about the possible liability of the directors. Okay, I think that will be it for the out-of-court restructuring. So, Czarek, please go on with the court.
Okay, right now I would like to discuss a little bit court restructuring, which may be a solution as well if we will not succeed in out-of-court restructuring usually. First of all, I'd like to indicate that the purpose of the court restructuring is first of all to avoid declaration of insolvency of the debtor, of bankruptcy, sorry. And we usually do it through adoption of arrangement with the creditors. And at the end of the day, one of the ideas behind the court restructuring is to safeguard the rights of the creditors. And in Poland, we have in general 4 restructuring types of proceedings. The first one, and at least complicated, is the arrangement approval proceedings. In Polish, it's postępowanie o zatwierdzenie układu. The second proceedings that we have is accelerated arrangement proceedings. It's in Polish przyspieszone postępowanie układowe. While the third one is the arrangement proceedings, which is postępowanie układowe in Polish. And the fourth one is the remedial proceedings. It's postępowanie sanacyjne, sorry, in Polish. Due to the Covid-19, the Polish legislature decided to introduce the new one, the type of restructuring proceedings. It's in another bill than the restructuring law, but still, this is the simplified arrangement approval proceedings, which is in Polish uproszczone postępowanie o zatwierdzenie układu. I will discuss the fifth proceedings later at the end of this presentation, as the law passed into the provisions passed. The provisions came into force on 24th of June, so it's pretty new proceedings, and so far it's going to last only 1 year. So right now, let's maybe at that point I would like to indicate as well that it's not like everyone may apply for the restructuring proceedings in Poland, because the Polish legislature decided that first of all the entrepreneurs, they are entitled to apply for this restructuring. As entrepreneurs under Polish law, they are in general natural persons conducting business activity, as well as companies, as well as partnerships conducting business activity as well. Additionally, it's been decided that limited liability companies and the joint stock companies, even if they do not conduct business activity, they still may apply for the restructuring proceedings. As well, the partners with unlimited liability for the partnership's obligations. For example, it's a general partner in the limited partnership in Poland. And the partners in a professional partnership, they may as well apply for the restructuring proceedings as well. There is also obviously a condition who may apply, because these entities, they may apply for the restructuring proceedings only if they are insolvent or they are at risk of insolvency. In general, an entity is considered insolvent when it's not able to pay its due debts, while the entity is at risk of insolvency, while it's very probable that such situation, which is a lack of abilities to pay its debts, may happen. What is also interesting is that some kind of entities were excluded from the right to apply for the restructuring proceedings. For example, branches of foreign entrepreneurs, they may not apply because such branches, they do not have legal personality under Polish law. But also branches of foreign banks, as well as domestic banks, credit unions. And what is also interesting is that investment funds, they may not apply for the restructuring proceedings under Polish law. The same rule as well applies to the insurance and reinsurance companies. This is how the Polish legislature decided. So in case of these entities, maybe it would be easier to try out of court restructuring, but obviously the question is whether they are able to communicate with all the creditors, because such entities have quite a lot of creditors. If they will not able to do it, what they may have as solution, the bankruptcy proceedings, but this is not, we will not discuss it right now. I would like to, because as I said, we have in general, let's say, 4 main restructuring proceedings, and there are some differences. There are differences between them, and we should know them to choose the most suitable proceedings for the debtor. First of all, what is interesting is that in case of all 4 proceedings, the debtor may apply for the proceedings. However, for initiation of the proceedings. However, only in the remedial proceedings, the creditor may do it. What we need to take into account as well is that some thresholds of disputable claims were introduced in case of arrangement approval proceedings and accelerated arrangement proceedings. If the amount of disputable claims exceeds 15%, then the debtor may not, shall not apply for initiation of such a proceedings, or he's not entitled to carry on these proceedings. In case of arrangement proceedings, it's otherwise, because if the amount of disputable claims is below 15%, he shall not, this entity shall not apply for these proceedings. And in the case of remedial proceedings, there are no such limitations. So regardless of the amount of disputable and undisputable claims, the debtor or the creditor may apply for initiation of such proceedings. In general, as I said, the arrangement approval proceedings, which is quite not so complicated as the other proceedings, and it's quite main part of it happens out of court. I will just discuss that a bit later. And because of these 2 factors, this proceedings is quite short comparing to others. The accelerated arrangement proceedings and arrangement proceedings, they usually last longer, while the remedial proceedings is very, comparing obviously to the other proceedings, it's complicated. So it's quite long. what the debtor needs to take into account as well when choosing which proceedings should follow is that within the arrangement approval proceedings, the debtor is still entitled to manage its enterprise, but it's controlled, not supervised, but controlled by the arrangement supervisor. The arrangement supervisor is in Polish nadzorca układu. What is interesting is that in accelerated arrangement proceedings and in arrangement proceedings, the debtor still is able to manage its enterprise. However, for the actions that are out of the ordinary administration, this entity needs a consent of the court supervisor, which is nadzorca sądowy. As this court supervisor, which is appointed by the court, he supervises the actions taken by the debtor. Under Polish law, there's a difference between control and supervisory. That's why there's a small important difference between these two. Between the arrangement supervisor and court supervisor and its obligations, duties. What is also interesting, if in case of accelerated arrangement proceedings or in case of arrangement proceedings, if the debtor performs any kind of action without the consent of the court supervisor, if such a consent was required, so which is an act beyond the ordinary administration, such an action is invalid. So it's quite important. And under the remedial proceedings, the debtor loses its management abilities in the way that the court appoints an administrator, and this administrator starts managing all the enterprise of the debtor. Another, it's an advantage of starting, an additional, let's say, advantage of starting of the restructuring proceedings relates to the suspension of the enforcement proceedings, because in case of the arrangement approval proceedings, such proceedings are suspended, but it happens only when the arrangement has been approved by the court. Which in fact happens quite lately at this stage of the proceedings. But in case of accelerated arrangement proceedings and arrangement proceedings, such enforcement proceedings are suspended as well. However, it happens upon opening of the restructuring proceedings, and opening of the restructuring proceedings, it's in fact issuing an order of the court on starting this kind of proceedings. And it happens in the earlier stage of the proceedings. We need to also point out that if under the accelerated arrangement proceedings and arrangement proceedings, if there is an enforcement proceeding started, and this proceedings relates to the property, to the debtor's property that is secured by that is encumbered with pledge, mortgage, maritime pledge, maritime mortgage, registered pledge, tax lion, then such enforcement proceedings are not suspended, because these kind of creditors have, let's say, strong rights which shall not be violated. And within the remedial proceedings, which is the most complicated, let's say, maybe, it's that any kind of any kind of enforcement proceedings is suspended upon opening of the procedure, of this kind of procedure. What is also good, let's say, for the debtor, and what may make him to start with this restructuring proceeding, is an issue of possibility to terminate some essential agreements by the other parties. Because in case of accelerated arrangement proceedings and the remedial proceedings, the other parties may not the other parties may not terminate agreements like tenancy, lease, bank account, guarantee agreements. It is allowed under the arrangement approval proceedings. And right now, I would like to focus on the procedures, how it all looks like in reality. So maybe I will start with the arrangement approval proceedings, which is in Polish postępowanie o wycenie wkładu. And main part of these proceedings happens out of court, because at the beginning, the debtor concludes an agreement with the restructuring license, with the licensed restructuring advisor. And the advisor helps the debtor to prepare, for example, to prepare its restructuring plan, and then there is then in cooperation they set the arrangement date. Arrangement date is a date when they decide that formally that this kind of proceedings will start. And after that, the debtor informs the creditors about the arrangement that the debtor would like to conclude the arrangement, and the creditors are provided with cards to vote with the arrangement proposals, with the description why it has happened and why it is favorable for the creditors to conclude such an to agree for the adoption of arrangement. And then the creditors vote. Once they vote and the majority required is obtained, the arrangement is adopted. And after that, the debtor applies to the court. At this stage, after these actions, applies to the court for adoption of the arrangement. Previously, it does not cooperate, say, with the court. The debtor does not cooperate with the court. And if the court finds the arrangement admissible, and for example, it does not violate the law and does not violate the rights of the creditors, then it approves the arrangement. Later, the debtor shall perform the arrangement, and when it's performed, then the court issues an order on performance of the arrangement, which means in fact that the proceeding is finished, and later the debtor may carry on its business activity without any let's say, without involving any entities like license, like a restructuring advisor. It is a little bit different in case of accelerated arrangement proceedings, because at the beginning, in general, the debtor does not have to conclude an agreement with the restructuring advisor, but it prepares, the debtor prepares a documentation that is needed to apply for the proceedings, like initial restructuring plan, the list of the table of claims, and they apply for the court, and explains why initiations of this accelerated arrangement proceedings is justified. If the court opens the proceedings, then it appoints the court supervisor, and the court supervisor prepares a restructuring plan, a final restructuring plan, and a table of claims. And then this documentation is submitted to the court, and the court agrees with that. It notifies, it tells the court supervisor to notify the creditors about the arrangement, about the proposals of the arrangement, and then the creditors are provided as well with information that with the cards to vote on the arrangement, and later they may vote either in paper form using these cards, or they may meet at the creditors meeting, because the creditors meeting is set, and during this creditors meeting, the parties finally decide whether the arrangement has been adopted or not. At this meeting, usually the judge commissioner approves the arrangement, and later it is submitted to the court so that the court may approve the arrangement. And later is the same as with the arrangement approval proceedings, which is that the debtor shall perform the arrangement, and the court shall issue an order on performance of the arrangement. In case of, I see that we don't have so much time. In case of remedial proceedings, it's a little bit similar to the accelerated arrangement proceedings. However, what's the difference when the proceedings is open, which means that the court issues an order on starting these proceedings, the administrator is appointed, and he takes over the whole enterprise of the debtor, and then the administrator takes more of the actions within these proceedings. What is interesting is that within this, when the restructuring plan is adopted, some commencement remedial actions may be taken. Like, for example, the employment relationships may be terminated, even if in normal conditions it shouldn't happen. It's not allowed. Maybe I will go further, because what we should also take into account is that and usually from the debtor's perspective as well, that the arrangement may include some specific conditions. First of all, which is quite common, is that the claims may be reducted. This is one of the aims of this arrangement, because from the debtor's perspective, something needs to change with its debts so that it may carry on its activity. And one of these tools is to reduce the claims. Another is that the claims, the debts may be paid in installments. Obviously, the payment days may be postponed as well. Obviously, all these tools they are included in the arrangement proposals, and if it is adopted, it takes place. It happens with these claims. What's also interesting is that some claims of the debtors, of the creditors, could be converted into shares or stocks of the debtor. The arrangement proposal may foresee as well that some of the debtors' assets will be sold, and some kind of agreements, some essential agreements as well, may be negotiated. Some external financing or external investors may be look for. Also, the arrangement may, according to the arrangement, the structure of the company may change. For example, some smaller teams will be created, or some members of the corporate bodies will be. I mean, the number of the members of management board or supervisor will be reduced. What is also interesting is that if the arrangement is adopted and a specific claim was covered by this arrangement, even if the creditor voted against the arrangement, but his claim was included in this arrangement, then these tools, these conditions will apply to his claim as well. So even if he was against the arrangement, his claim could be reduced, or the payment date could be postponed. So this is the risk for the creditors in case of arrangements in general. Yes, and right now I would like to relate to the fifth restructuring proceedings that I mentioned in the beginning, which is a quite new simplified arrangement approval proceedings. So far, these provisions, they are to apply only for a year and 2 days, because they came into force on 24th of June, and the possibilities to use that tool will expire on 30 June 2021, which is over 1 year. In this case, it's similar as in arrangement approval proceedings. The debtor, because the debtor concludes an agreement with a restructuring advisor, and then the debtors prepare arrangement proposals, table of claims, and table of disputable claims, which are later handed over to the arrangement supervisor, which is similar. But in this case, the debtor on its own publishes in the official Code and Economic Journal, economic journal, in Polish it's Monitor Sądowy Gospodarczy, information that on opening of the proceedings. So the court is not involved in that. So the debtor on its own decides that the effects, the results of these proceedings will take place. And obviously, then the arrangement proceedings, the arrangement supervisor informs the court about opening about this publication, and some creditors may try to challenge them. Another step, similar as in arrangement approval proceedings, is that the creditors are provided with the voting cards, with the arrangement proposals, with the description of what happened and why we follow these proceedings, and then they vote. If the arrangement is adopted, which means that the required majority was reached, then the supervisor, the arrangement supervisor, acknowledges adoption of the arrangement. And later the debtor submits to the court to approve the arrangement. And it shall take place within 4 months since publication in this economic official code and economic journal. And what are main features about these proceedings is that in this case, the debtor requires consent of arrangement supervisor to perform any actions that exceed the scope of ordinary administration. And this limitation does not take place in, let's say, in arrangement approval proceedings, in the first or fourth proceedings that I described previously. But in case of simplified arrangement approval proceedings, such limitation was introduced because to secure the interests of creditors. Because with what also is important to know, that the enforcement proceedings regarding the claims that were included in the arrangement are suspended. It happens upon upon opening of the proceedings, which is announcing in the official code and economic journal. And as I said, it happens without any, the court is not involved in this action. So on one hand, the debtors may try to misuse this law, I think. Say it that way. And new enforcement proceedings within this time shall not be initiated as well. The debtors' claims shall not be set off, which means that the Polish legislature decided that the debtors shall have possibility to obtain some funds to exist and to carry on its activity. Similarly is in other proceedings, some essential agreements shall not be terminated by the other party, like lease, tenancy, bank account, or credit facility agreement. Yes, as I said previously, the creditors may apply for annulment of the announcement in the official code and economic journal if the opening of the proceedings leads to the detriment. And if this publication in the official code and economic journal, which means starting the simplified arrangement approval proceedings, it was made in bad faith by the debtor, then the creditors may apply for compensation. As I said, so far it's a temporary solution, but there are voices that it shall be prolonged. So maybe it will not be only for a year, but it will be for a longer period of time. We will obviously see what happens with the economy, because if entities will go bankrupt or would become at least insolvent in a way that they will be able to proceed with this restructuring proceedings, maybe the legislator will decide to let them use this simplified arrangement approval proceedings. Okay, so this is it as I'm concerned. Please let us know if you have any questions, if there's anything we could answer.